We begin with breaking news for you at noon. Former Sangamon County Sheriff's Deputy Sean Grayson is set to be released from jail on Friday. He's accused of killing Sonya Massey in her home after she called 911 for help.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. If you haven't gathered by the opening clip that was played at the beginning of our video, I have some unfortunate news to share as far as an update on the Sonya Massey killing by former Sangamon County Deputy Sean Grayson. After a hearing on the trial court's decision to deny pretrial release, the appellate court in the state of Illinois has basically reversed the trial court's order and has sent Mr. Grayson's case back to the trial court for them to set pretrial release conditions. So I want to run through the news story real quick, and then I'm going to go through the actual opinion from the court with you so that you'll kind of get an idea of why the court decided what it decided, and we'll kind of clear up a couple little things that may not be obvious. With that, let's watch the news story brought to us by WCIA News, which is a CBS affiliate, and then we'll come back and talk about it afterwards.
Thanks for joining us this afternoon. I'm Taylor Mitchell. Grayson appeared in court today over Zoom. WCIA 3's Theodora Coulivares was in the courtroom watching it all unfold, and she joins us now live in our Capitol newsroom. Theodora, good afternoon. What happened?
Well, good afternoon to you too, Taylor. Today, the court set up two court dates for Sean Grayson. The first one is this Friday, and that's a hearing to set up conditions of release for Sean Grayson. All of this stems from a ruling from an Illinois appellate court last week. They unanimously ruled that Sean Grayson should be released from behind bars, saying the decision to detain him was improper. In their ruling, the court said that prosecutors failed to prove that no conditions could be put in place that would mitigate any danger that Sean Grayson could pose to the community. Sangamon County State's Attorney John Milhiser said today in court that he plans to file a petition to appeal that decision to the Illinois Supreme Court. He's also going to file a motion to stay the mandate, which would keep Grayson behind bars as the appeal process plays out. Today, one of Grayson's lawyers says his legal team is operating under the assumption that as of now, Grayson is going to be released on Friday.
So as I mentioned before, what's happened is pretrial detention is governed. In most states, there's like a set of factors. And in Illinois, there's a specific law called the Pretrial Fairness Act. Now, blue states are a little better at this particular aspect because many of them are trying to eliminate the cash bail system. And I have, different personal thoughts one way or the other about that kind of stuff, but that doesn't really matter. My personal opinion doesn't matter about it. I'm just basing it on the legal aspect. And generally, guys, if you're seeing me say something in videos, it's probably not how I feel personally if I'm talking about the law. Now, I might be giving my opinion on whether an officer's a chicken shit or whether, they should be arrested or something like that. That's my personal opinion. But when I'm arguing stuff about the law, I'm talking about the law. I'm calling balls and strikes, and I couldn't tell you the number of times that people take some issue with what I say as if it's like a platform for me that I'm advocating for. I'm not. I'm just telling you how the law sees it and what the process is as it relates to legal processes. I do some preaching and I do espouse some philosophy here in some of my closing arguments and that kind of stuff, but most of the time I'm trying to do a straightforward balls and strikes legal analysis without any sort of political implications. But the Pretrial Fairness Act is probably a good law. The downside to having a good law that is designed not to keep people who are poor in jail when they can't afford a good lawyer to make these arguments and get them out is that the arguments are also there when a police officer crosses the line and does what Sean Grayson did. And so what we have here is we have probably, now I don't have any way of knowing this for sure, but my guess is that Sean Grayson probably has a union-funded or union-sponsored attorney or somebody supplied by the Police Benevolent Association that has dug into this Pretrial Fairness Act and has brought out some good legal points, right? I think that Sean Grayson should be thrown in the jail and locked away for the rest of his life. I don't want anyone to get that twisted. That's my personal opinion, and it's my professional opinion based on what he did. But the law probably will not allow that. So what we're going to do is we're going to walk through the arguments that were made in the appellate court hearing, and then we're going to talk about what happens next, and then we'll come back and close it out. So just real quick, I'm going to pull up the actual written opinion from the appellate court, and we're going to go through it. Okay, so here you see it's in the appellate court of Illinois, 4th District, people of the state of Illinois versus Sean Grayson. The appellate court reversed the trial court's pretrial detention order and remanded for a hearing on conditions of pretrial release because the state failed to introduce clear and convincing evidence that no combination of conditions would mitigate any danger defendant posed to the community. So it goes on to say here that law enforcement officers are entrusted with the responsibility of responding to dangerous situations for the protection of the public. Defendant Sean Grayson, a former Sangamon County Sheriff's deputy, is alleged to have violated his duties in the gravest manner. He is alleged to have shot and murdered Sonya Massey during a visit to her home in response to a 911 call reporting that there was a prowler in the neighborhood. Whether defendant is guilty of these offenses, and if so, what punishment he will receive, are questions that have not yet been resolved. The issue before the court is not the defendant's guilt or innocence, but whether he should be detained prior to trial. Specifically, the question is whether the trial court erred in finding that the state proved by clear and convincing evidence that defendant poses a threat to the safety of individuals or to the community which no condition of release can dispel. And the trial court found that the state met its burden of proof. We hold that the court's finding was unsustainable on the evidence the state supplied. Now, I went through this with some of my commentary on our preliminary hearing videos that I've done, like the one with Judge Fleischer and the one with the Kentucky judge that was murdered by the sheriff. So the state has the burden of proving to the court that these elements are met as far as why he should not be released. What the appellate court is saying here is that based on what we see from the record, we don't believe the state met its burden in proving this. And I'll be honest with you, I'm not sure the state can meet its burden. We're going to go through the elements here and we'll talk about why, but I think this guy's going to be walking. I think when the hearing comes on Friday that he's going to be a free person, subject to probably some pretty strenuous pretrial conditions like maybe an ankle monitor and that kind of thing. But I believe that he's going to get out. So let's get back to the opinion here. So it says the fundamental premise underlying pretrial detention based on the defendant's likelihood of future dangerousness is that it does not constitute punishment before trial. So this is the big thing that they're arguing about. And you guys will get a good chuckle out of this because you and I both know, if you just think about the Phoenix, Arizona case where Tyrone McAlpin sat in jail after he got beat nearly to death in Phoenix by those two police officers. He sat in jail for 24 days, but he wasn't there because they denied his release. He was there because he couldn't afford to make the bond. In this particular case, what's happened is the court said, we're not going to set any conditions. We're not going to give a bond. We're not going to, not even $1 million. Because at $1 million, that, potentially that some pro-law enforcement groups could raise a bunch of money and get him out, right? So the court has said, we're not going to give you a bond condition whatsoever. We're not going to make any conditions available for your release. And that's where they're going to have a hard time keeping that standard up. Because again, the McAlpin case in Phoenix, Arizona wasn't that he didn't have a bond, it was that he couldn't afford it. So the opinion goes on to say, in Illinois, pretrial release is governed by Article 110 of the Code of Criminal Procedure, commonly known as the Pretrial Fairness Act. And the code provides that every defendant is eligible for pretrial release and presumed to be entitled to release on conditions imposed by the trial court, irrespective of the seriousness or nature of the offense. So it doesn't matter what he's accused of doing. The most heinous crime that you can imagine. And first-degree murder is there, right? That's it. But it doesn't matter to the court. What matters to the court is that you have a presumption of innocence and you can't be punished pre-trial when your guilt hasn't been proven or established as a matter of law. So the code allows for the state to file a verified petition for a denial of pretrial release on the basis of either dangerousness or flight risk. So there's only two ways that the state can really justify keeping you in jail pre-trial, and that is if you're a danger to the community or you're a flight risk. Well, they didn't make the argument that he was a flight risk, and so the only thing left to argue is that he was a danger to the community. And so there are three separate elements that have to be met in order for the court to deny pretrial release. And so the opinion goes on to say, to detain a defendant on the basis of dangerousness, the trial court must find that the state has proven the following three elements. Number one, the proof is evident or the presumption great that the defendant has committed an offense. Well, I think to me that's pretty clear. So they've passed the first element. It's the second element they're going to have a hard time with. The second element is that the defendant poses a real and present threat to the safety of any person or persons or the community based on the specific articulable facts of the case. And that's where the problem lies, because Sean Grayson, if you remember, does actually have a criminal history. He has a history, I think, of 2 separate DUI convictions, but nothing else, right? And so the element being so specific, it's based on the specific articulable facts of the offense. Well, the specific articulable facts of the offense indicate that Sean Grayson is a danger to the community because he was cloaked in the armor of the state as a law enforcement officer with great authority and power to use up to and including deadly force against people. And that is the capacity in which he was dangerous. The third element that they look at is whether or not there can be any combination of conditions that could render whatever threat he makes to the public safe. And so the defense is going to probably successfully argue, well, Judge, if it is in fact the case that Mr. Grayson was on the night in question, based on the specific articulable facts of this case, a danger to the community, that danger to the community would be confined to his decision-making behind the badge of a law enforcement uniform. It wouldn't be based on something that he's done out in the public in his private capacity. And Judge, there's an ankle monitor potentially, there's a house arrest potentially, there's GPS devices that could be put on him. I mean, there's so many different things that could be done to mitigate any potential danger. But the biggest one is that he's not a law enforcement officer anymore. So the state is not putting him in a position where he can make life or death decisions about anybody else in the community. And so therefore, that based on the specific articulable facts of this case, if you remove the condition of him being able to just go freely whenever he wants, if you put a limiting device of some sort, whether it's house arrest or GPS locator device or ankle monitor to alert the authorities or his pretrial release officer for when he leaves the house, and you remove the authority of the state as a law enforcement officer, then you've rendered whatever threat, if there was a threat, completely moot. If he is ultimately convicted of this crime, there still wouldn't be anything in the record to suggest that there's any other capacity under which he could be considered a danger to the public at large, any more than you would put those sort of conditions on anybody else who had a previous DUI or whatever. And so, and that might not even come up because it sounds like this particular analysis is tailored completely to the facts of the case. So they may not even be able to bring up the DUI stuff. So essentially it's based solely on this right here, this thing that he did. And because this thing that he did was sponsored by the government in his capacity as a law enforcement officer, once you take away that authority and you take away his badge and his ability to go make life and death decisions about people, he's probably not, legally speaking, a danger anymore based on the standard in Illinois law. And so that's what you have to contend with. Because our holding addresses only the sufficiency of possible conditions of release to mitigate any danger defendant may pose, we will address the question of justification as it pertains only to the second and third elements, which is basically what I just said, right? The question in this case is whether the court's decision to grant the state's petition was reasonable based on this evidence. We note as well that the ultimate determination as to the truth of the allegation against the defendant will be made based on the evidence admitted at his eventual trial. It goes through basically everything that we have done in our previous videos, which again, by the way, I think there's some shadow suppression going on the algorithm because I've got 20,000 subscribers and about 150,000 monthly recurring viewers. And only under 5,000 people have seen either of these videos. And I did a very detailed frame-by-frame, step-by-step breakdown of the shooting. And still under 5,000 people have seen these videos. At the conclusion of the hearing, the trial court found that the state had met its burden of proof, granted the state's petition, and ordered defendant detained pending trial. The court summarized its findings on the second and third elements in a form detention order, shown here with the statutory factors in italics and the court's findings in ordinary type. So the defendant was a sworn officer with training, was accompanied by another officer. Defendant was aware or should have been aware he was being video recorded. Despite those safeguards and supervision from law enforcement, the defendant still discharged his firearm against an unarmed woman. He was in violation of his oath as a sworn officer, which is evidence he is not a good candidate to be in compliance with his conditions. He directed law enforcement not to render aid, which is counter to basic norms of public safety. Defendant was not using his body camera until after the shooting. Not being in compliance with body camera requirements is further evidence that points to him not being able to comply with his conditions. The defendant's characterization of the victim after the shooting, as contained in the video in People's Exhibit A, are such a departure from the basic expectations of civil society that they are evidence of the defendant's dangerousness and also that he could not comply with conditions. So in the follow-up hearing, the defendant filed a motion with the trial court seeking relief from its order denying him pretrial release, arguing that the court's findings on the third element were erroneous. The court denied the motion, reiterating its prior findings as follows. Electronic monitoring is insufficient. Electronic monitoring may detect a failure to comply with conditions, but it's not adequate to mitigate the threat. In the video, the impulsiveness of the defendant, as demonstrated by the amount of time that passes from the gun being drawn to him firing the gun, electronic monitoring does nothing to mitigate that threat. The police officer standing right next to him and recording him could not mitigate that threat. Also, home confinement and turning in weapons are insufficient because the court does not have confidence he would comply with conditions. Evidence shows that he didn't comply with his oath as an officer, he didn't comply with body camera requirements, and directed other officers to potentially not comply with their oaths as well. This is not mitigated by not being an officer. That is evidence that he does not comply with conditions of being an officer, but it's also evidence that he doesn't comply with conditions. The court is unsatisfied that he would comply with conditions of home confinement, or simply stating that he is going to turn over all his weapons. And I'll link this into the description, but you guys can read it. But basically, I'm just going to read what they said. Our review of the evidence here fails to turn up support for several of the trial court's findings. As such, the court's conclusion that the state supplied clear and convincing evidence to support these findings is necessarily unreasonable. Number one, defendant's training. Although the court emphasized that defendant was a trained officer who'd gone through personally hours of training, there is no evidence in the record concerning defendant's training or how it was violated. More importantly, the question before the trial court was whether there were adequate conditions to guard against any danger defendant would pose if he were released pending trial. Defendant's training may be an important issue at the eventual trial of the charges against him, but it bears little on this question. Number two, defendant's oath. The trial court emphasized that the defendant violated his oath as a sworn officer. Irrespective of what obligations bound defendant while he was a sworn officer, however, the evidence showed that at the time of the hearing, defendant was no longer a law enforcement officer subject to any oath. There was no way, then, that he could violate those obligations again if released. And this is what I was going through when I was talking about basically all of the danger that he posed are wrapped up within him being a police officer. Imposing pretrial detention solely for a past infraction when a similar infraction would be impossible on pretrial release crosses the line from permissible regulation of pretrial release to impermissible punishment. So the court is saying here that by the state making the case that everything that he did as a police officer is all of the reason that he should be detained prior to trial, the court is saying, well, here's the thing though. That is punishing him for what he did, not guarding against what he might do, especially in a situation where everything that he did was wrapped up in being a police officer, and what he might do is no longer possible if he's not a police officer. Which, if you remember my commentary before I started reading the opinion, and I hadn't read it yet, that's exactly what I said would be the argument. Number three, the basic norms of public safety. In its detention order, the trial court found that the defendant directed law enforcement not to render aid, which is counter to the basic norms of public safety. The record does show that the officers discussed whether any aid they rendered with the medical kit would be futile in light of Massey's severe injury, but they also summoned the EMS to provide aid, and the defendant still retrieved the medical kit. But again, these matters do not reasonably bear on whether adequate release conditions could be fashioned to mitigate any danger defendant poses as a private citizen, not as a law enforcement officer. On pretrial release, defendant will not be able to issue directives to other law enforcement officers or fall short in providing assistance when acting in a law enforcement role. Number four, body camera requirements. The trial court found that the defendant failed to comply with statutory body camera requirements by activating the video immediately before the shooting and the audio immediately after the shooting. Presumably, the court was attempting to analogize defendant's compliance with body camera regulations and his possible future compliance with GPS monitoring if ordered by the court. This is a strained connection. If defendant is fitted with a GPS monitoring device, it will not be up to him to activate it. Therefore, this analogy provides little support for the court's conclusion that pretrial release conditions would be inadequate. Number five, supervision from law enforcement. The trial court described the other deputies accompanying of the defendant as supervision from law enforcement. However, there is no indication that the other deputy had a supervisory role over defendant. Indeed, the court seems to have believed that the opposite was true, faulting defendant for directing the other deputy not to render aid to Massey. And then see the trial court's conclusions. To recap, the state introduced no evidence, much less clear and convincing evidence, of one, the training that defendant is alleged to have clearly disregarded, two, the provisions of the oath that defendant is alleged to have violated, or three, the Sangamon County Sheriff's Office policies that defendant is alleged to have deliberately disobeyed. Nevertheless, the trial court found clear and convincing evidence that defendant's unspecified noncompliance, together with his impulsiveness and disparagement of Massey, were such a departure from the basic expectations of civil society that no conditions of release would be adequate to mitigate the threat he posed to the safety of the community. D. Remand. Number one, conditions of the release. In previous appeals where the trial court's explanation behind its detention order was insufficient, we have vacated the detention order or remanded for a new detention hearing at which the court could properly explain its decision. Our reason is that the state should not be held responsible for the court's error when the state supplied sufficient evidence at the first detention hearing. Here, however, the state failed to supply sufficient evidence, so we hold the state responsible by reversing the court's detention order outright and placing the parties in the same position they would have been had the court properly denied the state's petition and proceeded to a hearing on conditions of release. Although our order has addressed only the conditions of release addressed at the detention hearing, we express no opinions as to what conditions of release may be appropriate on remand. So that's a little bit different, right? Normally they would say, okay, well, we disagree with the trial court, but because the state provided evidence, we're going to send it back and we're going to make the trial court hear the evidence again and make a different decision. Here they've said the state didn't provide any evidence and the trial court erred in not denying the state's petition, so we're going to bypass both of them and we're going to just act like the court properly denied the motion, and we're going to put them back in the situation they would have been in had the right decision been made based on the evidence the state presented. So the state doesn't even get a second bite at the apple to try to represent the evidence. And so the only hope now is that the state would be able to get the Supreme Court to intervene, but I can almost promise you 100% that the Supreme Court will see it the same way as the appellate court. And the reason is because what essentially the state has done is they've home-cooked the judge, right? The state has gone to the judge and they've said, hey, look, this is bad. You're a judge in this county. He's a deputy in this county. This is bad, bad, bad. This guy's got to stay in jail. And that home cooking got them what they needed. They got a few more months out of it, right? I don't like it. I want him to stay locked up forever. But the truth is, the state really didn't do anything except present evidence as to why he should be punished pretrial, because again, all of the dangers that he posed are eliminated by his badge being removed. In closing, I like these sort of pretrial detention laws. I like the fact that somebody who doesn't have the money to hire a $25,000 lawyer can still make these arguments, even if they have to make them in a pro se capacity or with court-appointed counsel, to be able to eliminate sort of the disparity that exists between somebody who has money for a great defense and somebody who doesn't. And the beauty of that is also the downside, because they apply to everybody equally. And that means that even when the police officer who did everything he did on camera still enjoys the presumption of innocence, he gets the same benefits that anybody else that was charged would get. So my prediction is that the Supreme Court of Illinois will either decline to hear the state's petition because they've got a sneak preview of what the state's going to say and what the appellate court said, or they're going to hear the state's evidence and still affirm the appellate court decision. And so I think probably Friday at 2:30, which is when this next hearing is going to be, what we're going to see is some pretrial release conditions, and Sean Grayson is going to be free. Now, I would be careful what I wished for if I was him, because I think he might be safer in jail than he is out in the public, but you never know. I think that ultimately he will get out. I don't think that they can keep him in there. I don't think that based on the way they've written the law in Illinois and their attempts at sort of eliminating cash bail, that they're going to be able to properly deny him this opportunity to be released and at least have an opportunity to get out without it crossing the line into punishment of a pretrial detainee who enjoys a presumption of innocence. Anyway, that's the update. I hope you guys got something out of it. Sorry if I was reading to you. I just wanted to speak it out. That way, if somebody is not great at like reading fast or keeping up with the thing, or maybe they don't like to read at all. I have family members that have dyslexia and reading is a challenge for them. They do everything on audiobooks. I know there are a lot of people out there like that. So I just wanted to kind of go along, work through the order with you guys, let you know where it stands, and then ultimately, if nothing outside of what I've predicted happens, I won't do another update video until something significant happens with the trial. But if this is different than what I predicted, I'll come back and probably do like a brief update just to let you know where it is. But I'll link the appellate court opinion in the description. If you'd like to support the Southern Draw Law channel, I don't do any types of memberships. I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Specifically for this video, I'll be leaving my 2 previous Sonya Massey videos in the end cards in case this is the first time you're seeing my channel or you're not familiar with the coverage that I've already done on this case. Until I see you again, take care. Always film your interaction with the police and keep your evidence to yourself.